Welcome to my YouTube channel. We are going to be considering rights today in jurisprudence. Rights. What are rights in jurisprudence? According to Salmond, rights are any interest or rights is an interest recognized by law. So if a person has an interest and that interest is not recognized by law, Salmond will not call it a right. But if a person has an interest that can be protected and recognized by law, example, your right to life, or if you're in Nigeria, chapter 4, section 33 or thereabout of our constitution provides for right to life. And in that instance, that interest is recognized and protected by law. So to Salmon, that is a right. To Holland, who is also another jurist, to him, he sees that rights are capacities residing in one person who can control the actions of others. So for him, rights are whatever resides in a person who can control the actions of others. That is right. So another thinker, Gray, says rights are powers people possess. So to Gray, it's not about the law, it's about what you possess in you. If you have a power to pull down the rain, it is a right. I don't know, I do not agree with that, but then that is his thinking. H.L.A. Hart says rights are interests persons can enforce. So to Hart, if you have an interest that you cannot enforce, that is not a right. We'll now move on to theories of rights. First, we have the will or choice theory of rights. The persons who are in this theory are John Locke, H.L.A. Hart, and others. To them, they believe that rights are the things that people can control by their choice. They flow from the will of the people. So if a right holder can choose to enforce the right, then he has a right. If a right holder has no power to enforce a right, that the person does not have that thing is not a right to you. So if I have a right to movement and someone restricts my movement, maybe false imprisonment and all, and I can go to court and sue on that, then that is actually a right. But if an animal, for instance, of course, because in this school of thought, they don't believe that animals have rights. So if an animal, for some proponents that think that animals have rights, if you breach the right of an animal, can the animal enforce the right? Let's say an animal is not supposed to be hunted down or the body parts taken and stuff like that, and you do that, but the animal is still alive. Can the animal enforce the right by themselves? No. The animal cannot enforce the right. So this group of persons, they believe that that cannot be, so we cannot say that animals have a right in that particular instance, since the animals cannot enforce that right. So for them, if you say something is a right, you should be able to enforce it, or you can also choose not to enforce it. It's by your will, it's by your choice. If you enter into a contract with someone and you have a right to be supplied the certain goods at a certain time and the person fails to do that, you can choose to enforce the right or just leave the person to karma. Do you get? So that is what this particular school of thought believes, that in this particular instance, right is something that you can choose to enforce, and that at your own will you can enforce or you can choose not to enforce it. But if you call something a right, and if someone does it or if someone breaches it, I cannot enforce it, and it's not by my choice, then it is not a right. Okay. Now, they believe that to have a right is to have power to enforce that right. So we also have the interest and benefit theory. For this particular theory, they believe that rights exist to protect the interests of people. It's not even about whether you can enforce it or not. But if a thing is not protecting your interests, it is not a right. It can as well be an imposition on you. So if you have a right for a child, against child labor, sexual molestation, and things like that, that interest or that thing that you call a right is protecting the interest of the child. So it is a right to the child. They also believe that rights must be something that is beneficial to the person who should enjoy it. So if a person cannot enjoy certain rights, then it is not a right. It could be anything at all, but if If I'm not enjoying it, then it's not your right. So in this school of thought, they also believe that before you can call anything a right, you should be able to consider the persons that you want to give it to. If you come to a society where persons are not even educated and you're giving them right to technology when they have not, when they cannot read or write, they don't even know the value of tech. I think that such things are not beneficial as far as this school of thought is concerned. You should first of all consider giving them right to life, right to basic education, right to maybe employment, so that they can now continue from there and now consider the other things that are lofty and maybe admirable. Okay, so you have some persons there who are the proponents of this school of thought. To them, they believe that a right exists when the law secures an interest of a person. If anything that you are doing does not consider the interest of that person, it could be an imposition but not a right. So under this group, infants who cannot enforce their rights do have rights. Animals who cannot enforce their rights do have rights. Mentally deranged persons who cannot enforce their rights do have rights. Also, every other person has rights. Now look at this scenario that we have here, because we are going to go into Hohfeld's theory of rights very soon. So A has a right to receive 200 naira from B under a contract. We're going to consider them later. A has a right to kill her own dog. A has a right to rescind the contract in the event of misrepresentation. A has a right not to be deprived on his or her life or Nigerian citizenship. Why do we look at all those things? Let us consider Hohfeld's theory of rights. Hohfeld was a thinker at the time, and he propounded that right is not one box fits all. According to him, rights do have, or they come in four different variants. The first is the claim right, the second is the liberty privilege, and then the next is power, and then we have immunity. So let's continue. The claim right, as far as Hohfeld is concerned, is the right that a person enjoys because someone else somewhere has a duty to grant that right. So if I say I have a right to 10 million naira, and that is because I entered into a contract with someone and I have supplied the person some goods, and the person is supposed to bring, or no, the person is now to pay me the 10 million naira, then I can say I have a right. Yes. Then I can say I have a right because someone somewhere owes me that duty. So if I say a person has a right to fair hearing, it's not because the right is inside me. It is a right that someone is under a duty to give to me. And who is under that duty to give me the right? It is the court. Okay? And so, or any other administrative body as the case may be. So in that particular instance, a claim right exists when someone has a duty to give it to you. Then you can lay claim to that kind of right because someone has a duty, and if the person fails to perform those duties, thereby giving you the right, then you can sue. So you see, if someone is being tried in court and the tenets of fair hearing, audio altering pattern, and all of that are not what was the word now? If the tenets of fair hearing were not observed during the trial, the person can sue. The person can literally sue against such. Okay. And then we also move on to liberty privilege. Liberty privilege, as far as Hohfeld is concerned, is a type of right where a person enjoys a thing and can choose to do a thing or not to do a thing, and nobody on the other side of the divide has any right to stop him or her from enjoying that right. Example, if I buy a car, I am at liberty to enjoy that car however I want to. If I choose to drive it today, I can. If I choose to park it at home, I can. If I choose to repaint it, I can. You are at liberty. That is a type of right. It's a right, but as far as Hohfeld is concerned, this right is called liberty. Okay? And no other person can interfere in your enjoyment of the way of your car. If I buy a piece of land and subject to restrictive covenants and subject to any other legal restrictions, right? I can choose to build a duplex on it. I can choose to make it a plaza or whatever for business. Maybe make it a business premises. I can choose to do whatever I want to do with that particular piece of land because it is mine. insofar as I'm not breaking any law, right? I'm not going against any law. It is mine and I can use it for that particular purpose. So in that particular instance, it's the liberty that I enjoy, and no one anywhere can interfere with my enjoyment of that liberty. But most importantly, I can choose to enjoy that thing in a certain way or not. It's optional. It's a liberty, it's a privilege that I enjoy all on my own. And now you can see so many, I've used the examples of buying cars and stuff. Now, freedom of expression, in my opinion, falls under liberties, because if I'm free to express myself and no one else can stop me from doing that, but I can choose to speak on issues or not to or not to speak on issues. I can choose when to speak on a certain thing or even to remain silent. Like, it's all on me. I get to call the shots when I express myself. I think it's a liberty. Now, under Hohfeld's theory, we have another class of rights where we have power and immunity, right? As far as Hohfeld is concerned, power is a type of right where a person who exercises it alters the legal positions of another person. A person who exercises it changes the legal positions of another person. So the person in that particular instance is going to have their legal position completely altered because of my exercising of a right. I'll use an example to send this home. For instance, if I, for any reason, um, if the legislature, example, in Nigeria has a power to make laws, right? Good. And once the legislature makes the law, every other person is bound by that law. Our legal position is changed. Look at our national anthem that was changed sometime in 2024. Once the legislature passed that national anthem act, what it meant was this: everyone is bound to start reciting that anthem at national gatherings, private gatherings, or what have you, at schools and other assemblies. That anthem is what everyone is going to start reciting. You are bound by it. Your legal position is altered by it. And if you fail to do that, you'll be held responsible. There are consequences if you. So that particular type of right is a type that when you exercise, other person's legal positions are altered. Now, the judges have a judicial power, right? They can sentence someone to death, to life, or even acquit you. When a person is sentenced to death, obviously, legally, they are bound to die. When a person is sentenced to 10 years imprisonment, they are legally bound to sit 10 years out in the correctional facility. The same thing applies when a person is acquitted. You are free. Go and enjoy yourself. You're free. That's it. So, and also we also have the power of presidential pardon in Nigeria, right? So when that particular power is exercised, someone who should have ordinarily been rotting in the correctional center can be set free. In either case, this type of right envisaged under or envisaged by Hohfeld says, at any time a particular person exercises this type of right called power, someone somewhere has their legal liability changed. Someone is liable for or against. Someone is going to be held. Someone's legal position will be changed. Someone will be altered. Someone's legal life is going to be, there will be consequences legally just because I exercise my power. The power to arrest. Once someone is arrested by the police, of course, you see that the police has a right to arrest. But Hohfeld is calling it a power. And once it is exercised, someone somewhere is going to take some liabilities. Okay, so we have used so many examples to send that home. Now, under immunity has this undertone that almost looks like liberty, but there is a slight difference. In immunity, we are saying that something is imposed on me, I enjoy something, and no one elsewhere can interfere with my enjoyment of that thing. But I myself have no right to choose or not to choose whether I can enjoy that thing or not. The enjoyment is imposed on me, unlike in liberty, where the enjoyment is meant optional. In liberty, you can enjoy it or you can choose not to. You can decide how you enjoy it. But in immunity, the right holder cannot decide that they don't want to enjoy the immunity. You must. Example, Section 308 of the Nigerian Constitution provides for immunity against civil and criminal actions on the president, the vice president, the governor, and the deputy governor of a state. In this particular instance, these power holders are not they cannot decide to take away the immunity. The immunity is imposed on them by law. They cannot take it away. They are bound that no personal action can be maintained against them throughout their tenure. Of course, when they are done with this with the service to the nation, and they acquire their individual identities, then actions can be brought in their personal names. But once they are in that position, you cannot maintain a personal action in their name. You may maintain an action in the name of Attorney General, President of the Federation of Nigeria, but not in the personal name. Example, right now our president is Bola Ahmed Tinubu. You cannot sue the name Bola Ahmed Tinubu at all. Personal or criminal, civil or criminal actions cannot be maintained against them. So in this immunity, everyone is disabled against you. So we're going to look at this particular image right here. You can see Hohfeld's conception. You see the claim right. There is a correlative of duty. You see the liberty. There is a correlation with no rights. That is, nobody can do anything. Then you have power. There's a correlation of liability. That is, anybody is liable and people are going to be liable. And then we have immunity, and there's a correlation of disability. This also applies here. This also applies here. First theory. I will continue. You can see in this particular slide, you have what we call the jural opposites and the jural correlatives. In the jural opposites, we are saying that there are rights and there are duties. So if you see, if there is a claim right, someone owes you a duty. If you enjoy a privilege, there is no one has any right to tamper with your privilege. If you have a power, someone somewhere is going to be liable once you exercise it. And if you are immune, everyone is disabled against you. But if you look at the opposite, it means when you have a right, somebody else actually has a right. So the opposite of right is no right. If you enjoy a privilege, nobody has a duty. But we're going to see that this is what's the word now? This is a criticism. We're still going to criticize we're still going to criticize Hohfeld's theory. So if someone has a privilege, nobody else has a duty to give it to them because you already enjoy it. Imagine if you have a car, you're saying someone else has a duty to help me to enjoy my car. No, it doesn't work that way. But we're going to see that there's a criticism to this Hohfeld's theory when we come back there. Well, if someone has a power, somebody else is going to be affected once they exercise that power. So you cannot say that someone is disabled. Someone somewhere is going to be legally liable once power is exercised. So it's an opposite. Just like what's an opposite? If someone is dark, you can say they are fair and things like that. Immunity. If someone is immune, nobody can do anything to them, and so you cannot say that someone is liable to do anything to them. And that is that on Hohfeld. So let us look at types of rights. In this particular instance, there are so many. I did not put enough there. So we have civil rights, we have social rights, political rights, economic rights. We also have cultural rights, as the case may be. So civil rights are the rights that basically focus on persons living in the society with decency. Its main focus is decent living, right? The focus on civil rights is decent living. Or before we go over, okay, let us critique Hohfeld's theory before we go over. Hohfeld's theory of rights is not so perfect, but then it's a good insight. You know, it gives us insight into the different variations of what we call rights. And now, for Hohfeld, one of the critics say that it mainly captures, or it fails to capture, moral or contextual dimensions of legal rights. It's just there talking about book or academic dimensions and definitions of rights. What about rights that are morally held? You know, right to take care of a person, right to take care of, what do you call that? Where will it fall in? Since it is not going to be a claim right, since it is not going to be a privilege, where will it fall in? Some persons say these rights, according to Hohfeld, are just too book perfect, but not too real, that he needs to touch grass. Now, another another criticism is saying that there is an interlap between power and liberty. I think I wanted to say something like that. When you see liberty, you are at will to exercise your rights, yeah? But then in power, In power, you are also, if you have a power, you can also choose to do a thing or not to do a thing, right? So if the legislature has a lawmaking power, you, what if they choose not to make laws and they choose to only pass the budgetary allocations for the year? Uh-huh. So you see that there's an interlap between power and liberty. Another person says, number three, what happens to persons who cannot enforce their rights? Where will you categorize them under Hohfeld's theory? What happens to persons who cannot exercise their rights? Where are they going to be under Hohfeld's theory? Are they going to, is it going to be a claimed right? No, because even though someone owes them a duty, but then they themselves cannot enforce it when the duty is not performed. Is it a liberty? How can animals have a liberty? You know, there's an issue. Now, there's also the issue of when you say if a person has a liberty that nobody owes them a duty, it is also a flawed statement, because if a person has a liberty to use their car however they want to, every other person has a liberty, has a duty not to interfere with their usage of that car. If a person has purchased a land, every other person has a duty not to interfere in that land. So you see that, if, let me go back to dual opposites. They said if there is a privilege, it means that there is no duty. It is not true, because if I have a privilege to use my house the way I want, every other person is under a legal duty not to interfere, because if they interfere, they will be called trespassers. You know, if I have my phone, every other person is under a, and I can choose to use my phone however I want. Every other person is under a duty not to interfere with my usage of my phone. If not, we can call them thieves. So this is a criticism on Hohfeld's theory. So we're going to come out in the next video to discuss types of rights and ways of acquisition of rights and all of that. See you in the next video.